Today's town hall is a practical dive into the CARES Act financial package that many carriers have started to access. To answer your most pressing questions, we have assembled a team of experts who are actively engaged with carriers, banks, and government agencies to provide the most relevant and actionable feedback on the CARES Act. I'm not going to spend too much time on the bios and the formality due to the amount of the content we want to get through in an hour and a half. Joining us today is Fred Price, CFO of Rayl, a dry van carrier based in Akron, Ohio. Next up is Randy Hooper, partner with Katz, Sapper, and Miller KSM, conceived this town hall concept. So our appreciation goes out to them for all their work to help carriers get through this difficult time. Dave Robinson and Steve Pletcher, both known well as attorneys and partners of Scopelitis. And finally, Michael Letsch, Senior Vice President with Bank of America. Welcome, gentlemen. Welcome all on the call. Just a little housekeeping on a disclaimer. This presentation is not designed for, nor is it intended to be used as legal advice. It is for educational purposes only. The opinions and views expressed herein are not necessarily those of FreightWaves, TCA, KSM, Bank of America, Scopelitis, Garvey, Light, Hansen, and Fury, and belong solely to the individual contributors. No rights are conveyed. So let's get started with the carrier's perspective on the situation, especially the application process. Fred, can you share your experience so far?
Sure, thank you, John. I'd be happy to do so. Our loan application here at Rayl Transport. I've been in contact with our bank for the last couple of weeks, really reviewing this continuing evolving process. We received the application last week, but it changed several times during that process, and we finally formally filed our final application on Friday around 3 o'clock. The overall process was fairly simple, not very complex at all. The calculations, however, are a little bit more complex. I think as we get into this presentation today, I think we'll flesh out some of those details. We anticipate using the CARES funds that we receive from this act to invest in our associates, to keep them working and productive, to help them support our customers and support their families during this crisis.
Thank you, Fred. And to bring carriers' day-to-day view on how we've been dealing with the information overload from the states, federal government, and webinars, how have you been working through all that?
Well, it's really consumed our entire senior management team the last month and a half. There's been an explosion of information at the federal, the state, coupled with numerous conference calls, video calls, newsletters, and a lot of questions from all parties alike. It's been amazing to watch the Truckload Carrier Association, firms like Scopelitis, Bank of America, certainly Katz, KSM, to provide insight and to help carriers through this process. Truly a proud moment for our industry. With being our location here in Akron, Ohio, our governor was kind of at the forefront of an early adapter of shutting down and stay-at-home orders. So we were kind of forced to be out in front of that almost immediately. Our HR and safety department have been very instrumental in that process. And what we've done is we've communicated through various channels, either through emails or through ELD communication blasts to the drivers, and even mailings at home to the families to make sure that we're clear in what our directive is. My takeaways to the listeners on this call is continue to ask questions of your professionals. And no question's a stupid question at this point in time.
Fred, thank you very much. Randy, can you please provide an overview of the payroll protection plan and the corresponding SBA loan?
Yeah, sure. So, and I'll try to do this as in a condensed fashion here because there's a lot to cover, and I'm sure we'll be talking about this for quite a bit. So a couple Fridays ago, when the CARES Act was passed, it was a $2 trillion bill, and $349 billion of that were funds that were an extension of the already existing SBA 7A loan program. So applicants who are companies of 500 employees or less can apply for a loan up to $10 million. And the borrowing base of that loan is determined, it's based on 2.5 months of average payroll. And so if certain metrics are hit, which we'll get into, the loan is ultimately forgiven. And then what's more is the forgiven loan is not taxable. So in short, you can get a loan for 2.5 months of your payroll that ultimately gets forgiven with a cap of $10 million per taxpayer. And then you'd say, well, then what's the forgiveness formula? So the loan proceeds can be used for 4 different buckets. So it's rent, utilities, interest on loans prior to 215, but really payroll is the main driver. And so at least 75% of the loan proceeds need to be used for payroll. And then you look into a formula that's got 2 buckets. So first of all, you look at your FTEs, and starting with the point of loan origination going out 8 weeks, you look at your FTEs as a ratio of your FTEs that were in place either at the beginning of the year or some period in last year, and you get the choice of those 2 ratios. And so, for instance, let's say you have already laid off some people and your FTEs have gone down, and you're 95% over the next few weeks here, and compared to the first 2 months of the year. So you'd have 95% of that loan forgiven. And then you would look at the next bucket and figure out if any single employee has had a dip in wages below 75% of their, to take them below 75% of their wages. And so if any one employee decreases by more than 25%, you would have a corresponding decrease to your loan forgiveness. So that's really the program in a very, very brief nutshell. That's the loan and then the forgiveness portion, with a lot more detail yet to come as we have some dialogue here.
Great, thank you very much. So how is this PPP loan in the CARES Act differ from the Economic Injury Disaster Loan, the EIDL? Michael?
Yeah, John, thanks for having me on today. There's really 2 differences between the Economic Injury Disaster Loan and the Paycheck Protection Program. In the Paycheck Protection Program, you do not need to prove that you had an economic disaster to qualify for the loan. You, by definition, if you meet the size test, you qualify for the loan. Additionally, the EIDL loans through the SBA sometimes they'll attach security, personal guarantees, and other security features to those loans. So different programs. And I know some have asked if we are going to, if the SBA is going to allow you to have both types of loans. And I think that's a little bit unclear at the outset of the CARES Act. But what is clear is if you have an existing EIDL loan in place today, that is an adder to the borrowing base for the PPP program. So that can add to the amount that you can borrow under the Paycheck Protection Program.
Very good, thank you. And Randy, what elements of the CARES Act are companies precluded from taking advantage of if they participate in the PPP?
Yeah, that's a common question. So there are two elements to that. There's an employee retention credit. So if a company has a partial shutdown or a shutdown altogether, the government will issue a retention credit up to $5,000 per employee, which you can take on your payroll tax returns. If you're taking that credit, it precludes you from taking this loan. And furthermore, the payroll tax deferral that a lot of people have been looking into, where you can push off the employer's portion of your payroll tax, half of it until 12/31 of 21, and the other half for the next year. You cannot do the payroll tax deferral and take advantage of the PPP loan. So those are the 2 things that you're precluded from taking.
Very good, thank you. And next question for David and Steve, Scopelitis. how do the Employee Retention Act and the Payroll Tax Deferral interplay with the Families First Act? And the second part of this is, does CARES supersede the first, or do they work in conjunction?
Thanks, John. Let me interject for just a moment and talk about just a brief overview of the Family First Coronavirus Response Act. Of course, our topic today is the CARES Act, and that is actually phase 3 of Congress's stimulus effort in response to the COVID crisis. Phase 2 was that Families First Coronavirus Response Act, which in simplest form provided 2 big benefits to employees. First, it provided 80 hours of paid sick leave for COVID concerns. And second, it amended the Family and Medical Leave Act to provide an additional reason for taking FMLA leave related to childcare, given that schools are closing and childcare facilities are closing. And importantly here, the big benefit to employers, of course, is that 100% of these paid leave payments are going to be recovered and recoverable by employers in the form of a tax credit. And so I just wanted to provide that brief introduction about what that statute is and let Steve expand a little bit about how it interplays with the CARE Act.
Great. And it's not that David and I don't like each other. We're just trying to do our part to social distance. So the short answer to this is that both tax credits really work together, as they both represent different types of payments. As David said, the mandated paid leave under the Families First Act allows employers that are subject to that mandated payment to take 100% of that payment against their payroll taxes, and the employee retention credit and the deferral of payroll taxes that Randy talked about are separate CARES Act relief programs. But also that with the credit allows employers to also take a credit of up to 50% of the qualified wages under that program against their payroll tax as well. And just briefly on what that means, to expand upon what Randy talked about, the maximum amount is subject to the credit is to $10,000, meaning that you can only have a maximum credit per employee of $5,000 for the credit. But employers that have 100 or more full-time employees in 2019 only count as qualified wages that are paid to employees that aren't performing any service, either due to a full or partial government suspension of operations or due to a significant decline in gross receipts of up to 50% or more. But employers that have 100 employees or less in 2019, FTEs can take a credit with respect to all wages paid to any employees during this period of full or partial shutdown or reduction in receipts. Now, as Randy mentioned, you can't take advantage of both. If you're taking advantage of the PPP, you don't get to take the credits. But if you don't take a PPP loan and you are required to make family leave payments, you can take advantage of the employee retention credit and the family leave credit as well, because with the employee retention credit, you cannot include in that the wages, the payroll, the paid leave wages that are part of the Family First Act. So they really work together and they aren't overlapping.
Very good. And Hooper, do you have anything you'd like to add in that regard?
No, that's a great summary.
Okay.
The only thing I might say is there's been a little bit of confusion because of the language, which absolutely precludes you from taking the credit on your employee retention. But the wording in the CARES Act seems like there's some room for, if you've started taking the deferral but ultimately get a loan, as soon as you're forgiven of the loan, then you have to pay the back tax. But I think the best guidance would be, if you think you're going to be getting one of these loans, maybe not do the deferral of the taxes to begin with. But yeah, no, that was a great summary from Steve.
Yeah, Steve, thank you. And thank you very much. Just a question about the impact of foreign ownership and the SBA loan eligibility. Who would like to weigh in on that one?
Yeah, so John, if you look at the affiliate rules for qualification of the SBA to meet their size testing, the affiliate rules, I think, clearly state that all affiliates, foreign and domestic, count towards both the revenue and employee count sizes. So I think you really need to look through to the entire umbrella of the company to meet the size test.
Excellent, thank you. So some industries have a by location rule. Does this apply to transportation? And Randy, I'd like to hear from you on this one.
Yeah, it's an important question. And when the CARES Act was rolled out, because of some of the industries that are being impacted, the restaurant industry, hospitality industry, hotels. So as it stands now, they've limited the by location rule to companies that have an NAICS code with a 72. And so unfortunately, while I've heard from a lot of carriers that said, well, I'm a little over, but if it was by terminal, I'd be able to participate. As it stands now, it doesn't apply to the transportation industry.
That's very helpful. Thank you. And perhaps let's talk about what a by location rule would mean to carriers. This would be a good way to include Fred in the early part of this conversation. Fred, what do you have on this?
Well, we understood it to mean by terminal or by operating location or by operating unit, say like a warehouse versus a terminal. However, since we fell below the 500 threshold, our entities had common ownership. We just filed one application in our case, and our rationale was the SBA interim final ruling, which indicated that no eligible borrower may receive more than one PP loan. So that's the direction that we took.
Very helpful. Thank you. Under SBA rules, some industries have higher employee thresholds. Will those apply under the CARE Act, or is it a universal 500 cap? And maybe Michael and Randy and whoever else would like to chime in.
Yeah, so you can meet the test, the size test in two ways. You can meet either the revenue test, which is by industry code, or you can meet it by the employee test. So the 500 test is not industry specific, except for I think Randy was mentioning the other exceptions, the industries that have a caps allowed to go above that. But it's either revenue or the employee test, and if you're over the revenue, you can get under with the employee test.
Very good.
Yeah, that's right. And maybe an important aside, it might not impact a lot of people on the call, but there are other industries that have, say, a 1,000 employee test. And so if you have two companies, a transportation company and a related company that would meet this other test, while you can't count them separately, perhaps this other entity would be under the overall test for that specific industry. And so the SBA has a long list on their website of other industries that might have a greater than 500 employee test. And so it may be worth considering if you have multiple interests.
Very good. So we'd like to transition to the next section, which is the calculation of loan and forgiveness. So thank you all very much for your information on the previous section. Based on feedback with our carrier members, there seems to be a lot of initial confusion about calculation of loans and what, if any, is forgiven after this is all done. Let's start off with Mike. What constitutes wages for calculating the loan amounts? And as a follow-on question, how are per diems treated?
Hey, John, I think Randy's going to take this question, but thank you.
Very good, Randy.
Yeah, that's fine. Yes, I'm sure, and I'll let Steve weigh in too in case I miss anything. But really, it's just based on your wages, your typical what you would call salary, wage, commission, your tips, vacation, and everything that goes into that. It would also include your insurance, your health insurance, retirement benefits, and then also payment of state and local taxes, so SUTA, et cetera. And then if I'm missing anything, Steve can let me know. But then to your follow-up question, and I'll be interested to get Steve's take because I'm not sure if I've discussed it with him. I believe that per diems would not be considered as wage and would not be included in that. But Steve, do you have an opinion there?
Sorry.
There you go.
There we go. First and foremost, we think the answer is no, they aren't included simply because expense reimbursements weren't included in the listing of the items that could be included for the payroll cost calculation. And easily they could have done that had they wished to. But separate and apart from that, even if there is possibly a bit of a gray area there, I would be very reluctant to try to shoehorn those in. Randy, I know your experience is as ours. We battle the IRS often on their efforts to try to tax per diem programs, and so I'd be a little bit reluctant to try to voluntarily include them in a calculation of payroll tax costs. It's obviously a big issue for many motor carriers that have per diem programs. It's a big expense, and we'll be watching the proposed comments, the comments to the proposed rule to see, if there are efforts to try to adjust that. But for now, I would definitely say no, I wouldn't include it. And then the only other thing I would add, Randy's did a great job on summarizing what you do include in that. You also, if you mentioned this, I apologize, I missed it, Randy, about excluding any wages in excess of $100,000. We only count up to $100,000 prorated for the first couple months of the year. And the frequently asked questions on the Treasury Department's website for the PPP loans also addressed this issue and made very clear that it's just the employee portion of the payroll taxes on employee compensation that get included. The employer portion does not.
Steve, that's great. And Michael, thank you. But again, for the two of you, in calculating the loan, the availability of a loan or the available loan, what constitutes wages for the 2.5 month rule? We touched on it briefly, but could you get a little deeper on that one?
Yeah, and so I think Steve did a great job on that, and maybe a question that's been coming up a lot as it relates to this is, can I include independent contractors in that calc? And if I do include the independent contractors, do I include them in the number that goes to the 500? And I'm curious, since I'm not a lawyer and Steve is an employment lawyer in the industry, to get his take on it. But when we first read the CARES Act, it seemed like the language was very ambiguous. And because the form itself kind of indicates that if you pay wages or if you have 1099 contractors, then you should be filling this out. And so I think it led people down that path of, well, potentially contractors would fall into this calculation. And so as we got the guidance from the SBA last Thursday, it was pretty black and white, at least to us, that contractors should be carved out and they would be able to apply for their own loan. And so that obviously takes them out of the equation for if they count for the 500 employees. So they would be excluded there as well. And so I know that there were some people that didn't love that answer if you were very heavy IC and thought that there'd be a way to increase your loan. But I think there's some other implications there where your contractors are exactly that. They are contractors and not employees. And so I'm sure Steve will have an opinion on that. But furthermore, there may be some carriers that have 400 employees and 150 contractors, and you really want that number throwing you in excess of the 500 employee amount either. So it's kind of one of those be careful what you wish for kind of deals. So in my summary on this issue, your independent contractors shouldn't count towards the employee count or in the wage borrowing base. Steve?
Yep, that's a great summary, Randy, and we certainly agree with that. Right now, after all the guidance that you've mentioned came out, it's certainly an unqualified no in our view that you would include independent contractors in the payroll cost calculation, or on the flip side, on the loan forgiveness calculation. And we agree, Randy. Initially, it was a bit gray. There is language in the legislation that you can certainly read to say we should include those folks, but we were always very cautious about that for the reasons you mentioned. It just didn't seem to make sense that you could include an independent contractor's payments in your payroll cost calculation, and then that same independent contractor could go out and get his own loan. And of course, that in the guidance that has come out since that you mentioned, Randy, that's exactly what they talk about, is they can go out and get their own loan. So So it's pretty clear, and we agree it is a huge impact on a carrier. Let's say that maybe a complete non-asset based fleet, and you don't have that many employees, but you've got 300 independent contractors, and your employee count is pretty small. It really isn't going to yield a very big loan under the PPP loan, but we'll have to wait and see again how the comments come in on the proposed regulation. But interestingly, we just saw today that somebody filed a lawsuit, or actually filed for an injunction in Colorado, trying to stop the implementation of the CARES Act because it denied independent contractors, and according to the clientele this lawyer was representing, that grossly negatively impacted businesses like that had a very large independent contractor base, but small in the employees. It was thrown out on procedural grounds, but it's clear that that's an issue that's out there, and we may hear more about it.
I think it presents an opportunity, though, for carriers to guide, help their ICs get these loans on their own. That helping carriers, especially when they're out on the road delivering essential goods to all of America, getting help to apply for these loans through their banking institutions, I think could do a really good thing in the economy and for those IC fleets.
Steve,
Yeah.
this is Fred. I have a question for you. If you got a minute?
Sure.
It's an easy way for the listeners to think about this is W-2 wages only. So W-2 wages would exclude per diems. It would exclude owner-operators, which are 1099. Is that maybe an easier way for folks to think about this?
That's a good point, Fred. I think that's a clear way to state it. I suppose there's an argument that when you talk about the non-taxability of certain benefit payments might fall into that as well. But certainly with respect to the two issues we're talking about, I agree. 1099s, obviously you don't include in the W-2 and clearly the per diems as well. So, yeah, I think that's a great way to talk about it.
So just to dig a little deeper, someone mentioned that some carriers seem upset by the independent contractor carve-out. But can you discuss maybe a little bit more, Steve, on the legal implication of claiming an independent contractor in the wages in the loan base should it have been allowed?
Yeah, I mean that's a good point, and Randy's comment was well taken. We know we had a lot of questions about it early on before the guidance became clear, and it's certainly disappointing for a lot of carriers. But even when it wasn't clear, as I said, we were cautious about it, not only because it wasn't clear in the law, but obviously we're concerned about maintaining the independent contractor status of owner-operators beyond this crisis. And there's certainly a concern, a potential concern that if we are including independent contractors in something that appears more of a payroll type calculation without more explicit guidance that says including them has no impact on their status as employee or independent contractor, we think certainly has the potential down the road of being used as a factor against a carrier in any kind of a misclassification setting. So we think that there is at least room for caution in that, even understanding the economic impact on the front end here. We think it could be a negative impact on the backside.
Thank you, Steve. So how do the affiliated company rules work? Are these based off SBA rules or the IRS rules?
I can take that. The SBA has its own affiliation rules, separate and apart from the IRS, for determining whether entities should be combined or affiliated for purposes of determining, whether as in combination you still are under the 500 employee threshold or the traditional small business concern calculation that the SBA does. The Treasury Department FAQs that I mentioned that are being updated kind of constantly here make clear that it's, and Michael might have a comment on this, but the FAQs make clear that it's the responsibility of the borrower and not the lender to make that determination of whether you have entities that ought to be affiliated or not. And the FAQs point you to the SBA regulation. It's 121.301F that sets forth the criteria for when companies have to be affiliated. But generally, these affiliation rules under the SBA, I think, are broader than what we might be used to in other contexts. Basically, they say that start out with the position that entities are affiliated when one entity controls or has the power to control another entity, whether or not that control is exercised. And then, according to the regulations, affiliation can be found. There's several different criteria they use. Among other things, it can be found on the basis of ownership. It can be based on stock options and securities. It can be based on common management or identity of interest. And again, they're far broader than I think we see in other areas. To me, it's the identity of interest factor that's potentially the most problematic. It does say that you can find affiliation, particularly with economic dependence, that can be found if an entity gets 85% of its revenue or receipts from one entity over the previous 3 years. There's exceptions to that. You can look to the contract. If it doesn't restrict the recipient from providing services to others, then you're not deemed controlled. And the SBA can look at your contract and make that determination. But generally speaking, related companies, for the most part, are going to be found to be affiliates, depending upon the facts and circumstances. But generally speaking, we think that's probably the case. Very helpful, Steve. Thank you. And Michael, is there anything you'd like to add?
Yeah, so I think it's interesting. The SBA and the CARES Act and Treasury have given guidance to the banks that we're not supposed to opine on their eligibility for these loans. The borrower opines on their eligibility and signs an attestation that says that they're eligible, and we're here to guide them and process the loans. Eventually, the SBA probably will peel back the onion and look at the documents that are submitted and will make its own determination if they were valid, especially at the forgiveness period. But I think it's clear that the banks don't weigh in on that topic, but we're here to guide borrowers if they've got questions.
Very good. Thank you. All right. So it seems like it could have a huge impact on carriers and brokers owned by private equity. Any thoughts on that at all?
Yeah, we've looked at that issue, and as in many things right now, the guidance may be a little bit less than clear at this juncture, but you really have to start with the SBA definition of what a small business concern is, and that guidance indicates that it's an independently owned and operated business. Although a business can be virtually any legal form, and ultimately, we just talked about the affiliation rules, and that's where we have to go back to. Does one entity have the power to control the other? And that's how we're going to determine whether an entity owned by a private equity firm would be combined with that private equity firm. And I'm not going to get too far into the details here, but based upon what we've looked at, and I'd certainly be interested in hearing if anyone else has a comment on this, it's going to be a very fact-sensitive analysis, but our research leads us to believe that it's probably more likely than not that a borrower that's owned by a private equity firm would be affiliated with that firm. But it's much less clear whether if the private equity firm has other entities, whether they would be combined with the borrower. Again, it's going to be a very fact-sensitive analysis to make that determination, but it's certainly possible, if not likely, depending upon the facts and circumstances, that the borrowing entity owned by a private entity equity firm would be combined with that firm.
Randy, anybody else like to weigh in on that?
I would agree with that. It's just really, it's tough right now. And so the SBA gave a little bit more guidance last Friday, which Steve's been alluding to. And it's just really hard to get over the 50% of voting equity piece. And so that's a really tough hurdle to me. And so I know this is being heavily lobbied right now. A lot of senators have been tweeting and making statements that they support this, have some favorable guidance for the private equity investors. But as the affiliation rules stand right now, it's pretty tough, unless perhaps the investor is an SBIC, that you would maybe get some favorable treatment here. And I guess related also to the 50% voting equity rule, I've had some clients say, well, what if I transfer ownership to an heir and I only keep 1% voting equity? And it kind of falls back to, as Steve alluded, there are other tests such as common management. So if your C-suite people are really managing both entities, there's a probability you would meet the test. And then the affiliation based on identity of interest. It seems like even if your heir or someone else that is related has that voting control, that you still don't meet that hurdle. So I'm sure, like everything else, a lot more to come on this. But initially, those are the things that are shooting us down to try to cross that hurdle.
Michael, could you go into a little detail on how the FTE calculated in the formula for the forgiveness side of it?
John, I think Randy's on that one too. Sorry.
Randy,
That's okay. Yeah, and
I'll jump in.
That's fine. Yeah, I'll probably defer to Steve on this, but I'll start off by saying, since he's the employment lawyer, but what I've read so far is FTE is based off of an employee that works, I believe, 30 hours, has a 30-hour work week. And so if you have two employees that work 15 hours a week, those two would combine to be one FTE. And then, of course, if you had one person, even if they're working 80 hours, you can't go more than one FTE per person, which has been asked. But that's how we've been viewing it. And so as we've been trying to help put pen to pad on what the forgiveness is going to look like, those are the rough numbers that we've been using.
Yeah, I think that's fair, Randy. And I'm going to sound like a broken record here, but guess what? We don't have any guidance on this in the Act itself as to how we define a full-time equivalent employee. So kind of like we're like Randy, absent that formal guidance, our best advice is to look to analogous circumstances, the most analogous of which, and that has the most detailed guidance we think is found in the ACA and how it interprets full-time equivalents, which is along the lines of the formula that Randy suggested. Interestingly, it's the ACA definition that's referenced in the employee retention credit guidance. So it's probably a fair assumption that we can use something like that. But this comes on, and I know we want to calculate it now. Obviously, it comes on the loan forgiveness piece of this, which is going to be 8 weeks from origination when loans start getting originated. We may yet see some guidance from the SBA one way or the other to say, yes, definitely use the ACA guidance or have another formula.
We talked a little bit about this, but what happens with companies with separate entities? Is there a chance to file for multiple loans?
Yeah, so I think it's clear that the guidance says that each individual borrower can only obtain one paycheck protection loan. But it's unclear. There's not specific guidance on it, but since they specifically call out each individual borrower, I think that means that if you have two affiliated companies under the same umbrella, if they both meet the size tests and they're both using separate information, I think that means they can get separate loans. Maybe someone correct me if that is the wrong read on the detail so far.
Yeah, I've actually seen banks doing it both ways. If there's a holding company structure where they'll make the operating entities get their own loans separately. And then I've seen it where it's at the holding company level. So I'm assuming there's more guidance on that because it doesn't seem like that's being consistent, just bank to bank.
Yeah, I agree with that. And Michael, I'd be interested in your take on this because we've heard from several different clients communicating with their lenders where some of the lenders are encouraging the consolidation into one loan based upon what they know is going to be an onslaught of loan applications. It's less to have to process. But I agree with both of you that we're seeing it both ways too.
I'd like to go a little deeper. What about companies with holding entities? Is the application done at the holding company? And the second part of that is, are there implications to filing at the operating entity if you have a related leasing company?
So I can't talk from a legal standpoint, but just kind of just pure math standpoint, if you're looking at the metrics that I know I kind of blazed through them at the first part of this call, but let's say you're relying on your debt payments or other payments that are occurring within a sister company to meet the obligations under the loan. It seems like that's easier to meet at the holding company level because everything gets consolidated. So to the extent you have interest or rent and it's not occurring within just the operating entity that has the payroll, it seems like it would be easier. But I just can't speak to the from a legal standpoint that.
Yeah, we tend to lean more towards, again, that consolidation based upon the affiliation rules that would require that. But we have clients that, for whatever reason, sometimes it's just administrative, that do want to file with their individual entities. But I agree with you, Randy. I think from a practical standpoint, it may make more sense if the banks are letting you do it, and you would otherwise meet those rules to do a consolidated loan at the holding company level. As to the employee leasing related entity, it really gets back to that same discussion about the affiliation rules and how we would put those entities together. If you were talking about a third party leasing company, the rules speak to that and talk about the credit being taken at or the guidance speaks to that and talks about credit being taken at the client company level. So I suppose you could apply that same thing same concept in a related company, related entity situation. But again, I think overall you're going to look at the affiliation rules to see whether we need to combine them anyway. So.
Yeah, speaking from the bank's perspective, there's the possibility that you could have two affiliated companies with different management, really different ownership under Absolutely. The same affiliate control, and there's obviously reasons why they might want their individual loans at those operating company subsidiary level. Bank of America specifically is taking the tactic because, again, this is an optional program. Banks are not required to be a participant in the program. Bank of America's tactic here is to support our best clients and to minimize the applications that we receive. We're only at the moment accepting applications from existing clients of record as of February 15th of 2020. So that's. Will the banks allow it? I think even Bank of America is allowing it at those underlying subsidiary levels as long as you meet that existing client test. But it's bank by bank. It's not uniform across the industry for sure.
Yeah, and that's a good point, Michael. I'm glad you made it because we talk about the affiliation rules and how broad they are, but if you have truly set your entities up to be independently operating entities, you certainly you have to look at the facts and circumstances of each of your operating companies, but by no means is it an automatic that these companies are going to be consolidated.
Well, you're all doing a great job because we've had a number of questions that have come in, but through our conversation, they've been answered. So good job, everybody. What about companies who have already started making cuts? Is it too late for them to course correct, or can they hire people back and can they get the full forgiveness amount?
I can start off with that one and let Steve weigh in maybe. So there is a provision that you can, if you've already made those cuts, you can rehire back until June 30th to get made whole on that. So it'll be really interesting. I assume that works for both parts of the calculation. We talked about an FTE calc and a decrease in wage calc. And so in theory, if you hired someone on June 28th, even though you only had that FTE, for a couple of days there, I believe you're unharmed from the FTE perspective. Now, that same person, obviously they're not going to have wages for that quarter. And so when you compare their wage for that quarter versus last quarter, it's going to be much different. But it seems like the spirit of that rule is to be unharmed if you hire people back. But that's definitely going to need some guidance on a specific calculation with examples.
Absolutely, I would agree with that, Randy. I mean, that's it in a nutshell. We've explained that to clients and kind of scratch their head and say, you mean if all I have to do is make sure I've got people hired back by that date? And as it's written right now, I agree with you. It seems as though if you've made folks whole by having that number count where it was, you shouldn't have to take a hit on your loan forgiveness based upon a reduction in the workforce.
Yeah, and
but then you have the issue though. You have to use them for eligible costs, correct? You'd have an issue where you might not have the payroll costs to support the forgiveness of the loan.
Absolutely.
So I'm actually a little bit confused on when that 8-week clock starts ticking. Is it the day you receive the loan funds? Is it some other arbitrary? I don't know what the date is when you start that 8-week ticking clock to add up your cost. Does anyone know the answer to that?
It talks about starting it, and Randy, jump in, or anyone else if wrong, but I read it as it starts on the date of the loan origination.
Yeah, I agree with that. And there's actually one other point to maybe make as it relates to both parts of the equation there. So I've had some people say, hey, I hope I'm going to get this loan, and even if I get this loan, I know that I'm going to have a decrease in either freight or whatever your workforce supports. And so I'm thinking about laying off 10 people. And so it seems like the calculation would suggest that you're better off to kind of spread the decrease over all of your employees and have people go down to, let's say, 95% of productivity, so that you're, number one, not losing the FTE, but two, so you don't have any single employee dipping below 75% of their prior wages. And so in theory, if you kept every employee at 80% productivity, you should be totally unharmed throughout the 8-week process. But if you cut a handful of employees, then you are absolutely harmed. So that may be a planning point there.
Yeah, I think, right. I mean, it's going to be dependent upon your business operations. I agree. If you can do that, Randy, I think it's a better way to go. But Michael, you brought up a good point too, and I apologize. I don't know if this was mentioned earlier or not, but on the loan forgiveness side, something new that was in the regulations, the proposed regulations that came out, was that your payroll costs have to be 75% of that forgiveness amount. So to Michael's point, if your payroll drops significantly, you're not going to get to make it up completely, potentially, with the other costs that you can add to it, because those are capped at 25%. Your utilities, your lease payments, interest on loans, and those sorts of things. So and it's a good point, Michael, that you made on that.
We had a lot of questions from carriers talking about when should I talk to my lender about applying and what is typically needed for the application.
You need to talk to your lender yesterday. We do expect the program to be fully utilized. The good news is that there are several members of the government, it's Treasury Secretary, President Trump, I believe, have all already stated that they would support adding to this provision of the law if needed, if it's used and it's used in the correct way and the funds get out there for what they're designed for, which is to keep people employed. Bank of America, as of last count, has received over 250,000 applications. And we've only been live since Friday morning of last week, so just a couple of days, 250,000 applications for over $30 billion. Banks are not, to my understanding, are not capped at an individual allocation. It's first come, first served. So if you think you're eligible, you think you can use the funds, you think you can seek forgiveness at the end of the period, I would advise you to turn in an application.
Hey, John, this is Fred.
Yeah, Fred.
The U.S. Chamber of Commerce has a really good, easy-to-read guide for small businesses to use in their checklist, and it answers a lot of the really basic questions around eligibility, documentation, the different calculations. And it's a good starting point, I think, just for the basics. You'll have additional questions I think, for the experts later on, but at least get you kickstarted in the process.
Very good, Fred. We'll see where we are.
Can I make one other point, John?
Yes, go
Real
ahead.
quick, I apologize. And just a reminder, as folks have talked about the process, Michael and Fred, yeah, don't forget about that part of it. There is an attestation that you're indicating that your business has been economically harmed by this downturn. So, and frankly, it's hard to see how anybody's business isn't going to be harmed. But if for some reason you're in a segment of the industry that is going great guns and you can't get enough drivers, it may be pretty tough to make that attestation.
Very good. I think less than an hour and a half ago, there was talk about the funding for the program, if I'm not mistaken. We all know it's possible that $350 billion allocated for the program will dry up quickly, especially after the first few days. Anybody like to speculate on that a little bit or talk about that a little bit?
I can jump on that one first. So I joked earlier with some people that I think I have the nerdiest Twitter feed in the entire country, because I've been following Steve Mnuchin and every major bank over the last 4 days to see what everyone's tweeting about, and different banks are posting the different levels that they've been funding, and so I've been very curious about that. And then I think it was about 12:30 today, Mnuchin tweeted that he has bipartisan support for another $250 billion to fund if this program does run short. So I think that everyone's concern was that $350 billion would run out. Of course, no one knew for certain, but it was nice to see that tweet. And then Mitch McConnell's office sent out an email about the same time at 12:30 with the same fact pattern that there's bipartisan support to fund another $250 as soon as possible. So I'm sure that they are seeing the numbers roll in and realize that 350 was short of enough.
From a carrier's perspective, Fred, did the worry about the program running out impact how you approach this?
Not really. We were pretty much all over this from the get-go. But based on the conversations today, it appears that more funds will become available. But as Steve pointed out earlier, the quicker you get going, the better.
Kind of interesting question here. Thank you for that, Fred. This question, is it true that each bank has been assigned an allotted amount of this $350 billion program?
John, to my knowledge, that it's not true. It is, and it's even in the Treasury guidance that it is first come, first serve. There have been a few banks that have been able to get actual dollars out the door from the SBA, but the major banks, because of the lateness in guidance from Treasury and others, it's been difficult to get our applications up and running. I'm very proud Bank of America was the first to get our application up and running Friday morning. Others have followed us quickly, and we are receiving documents from clients and processing loans. We hope to get them out as soon as possible, but it's not allocated bank by bank. And those, even the small lenders that have received an enormous amount of applications as well, small lenders, they will banks off of buy these loans off of the bank's balance sheets to relieve them of the capital requirements of having loans on their books. Mm-hmm. Small banks that maybe are inundated with these are going to get some relief, and we're going to continue to get these funds out into the economy and do the good that they're intended for.
It seemed that when things opened up on Friday, that the community banks were able to submit, but all the national banks held off to work out kinks with the SBA. Can anybody talk about this process and why some banks handled it differently?
I wish I could answer the why. I can tell you, just from Bank of America's perspective, we're taking a more conservative approach in checking documents, working only with existing clients, because there are certain things that the Treasury wants us to verify, or at least check off that we've done some diligence on the borrower to prevent fraud. I think smaller banks, they can react quicker. They have a more local touch, and that's great for small businesses, which is where a lot of these loans are going. So I'm glad they got the money out the door, and hope that it continues.
Well, we just got a question in here, and it says, shouldn't trucking companies apply for the loan on a consolidated basis versus as a single entity, since when they apply for the loan, when they apply for forgiveness, the outcome might be different. Anybody talk about that?
Well, that may go to the point we were talking about earlier when if you apply at the consolidated level, you may be able to apply other expenses. Now, to Michael and John and Steve both said we need to make sure that we have at least 75% going to payroll, but that may be the point that listener is trying to make, is at the consolidated level it may just be more simple.
Okay.
And I agree, it probably is.
That's,
I
I think,
agree with-
very helpful. Go ahead.
I agree with that as well.
All right, so it seems like there's currently no bright line test for decreased revenue to receive this grant. How harmed do companies need to be to accept these grants?
So the application says really all you're attesting to, and I'll read you from the Treasury application. It says, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. It's intended to be pretty broad, and people are supposed to apply to keep people employed, I believe.
Okay.
Yeah, and I guess to that point, there are other provisions in the CARE Act that have a bright line test. So if you have a partial shutdown and you want to take the employee retention credit, you have to actually have a decrease in revenue, I think maybe 50% or plus. But there's no bright line test here. But you do have to make a good faith statement that says you need the funds. And so it's not anyone can just go out and obtain.
Yeah, and Michael, I think it was you mentioned earlier, but it's not a bright line test, and I think you mentioned earlier, Michael, it's about getting this money out into the economy, and that's what they're trying to do. The only thing, look, you don't have to show any you don't have to have any evidence of that economic downturn when you make that attestation. I don't think it hurts though if you're able to track. We've lost customers, our revenue dipped by X amount, just to keep track of that or to keep it in a file. If there ever were any question, and I don't think there will be, but if there were, you've got evidence that, yeah, we didn't just make the attestation. We had some good faith belief based upon the numbers we were seeing.
Yeah, I mean, the SBA, Treasury, and others, we've talked a lot about on this call that there's not a lot of clear guidance. We haven't even gotten to the forgiveness period yet. What's going to come up when that comes up, and there's going to be a number of questions that are unclear in that process. So again, documenting anything that proves your need or your attestations on the form, I think, are clearly wise.
Yeah, I'd like to just go back to this this person who sent this question, and it said, this is the question about, shouldn't truck companies apply for the loan on a consolidated basis versus as a single entity? But the second part of this is, when they apply for the forgiveness, some of the allowable expenses might be expensed in multiple affiliated companies. Any thoughts on that?
So is the question around, I might have a real estate holding company that leases property, and that's part of the group that's eventually going to be paying rent payments?
They aren't
Possibly.
specific, so I don't really know the answer
Right.
to that. I don't know. Any thoughts? Okay, we have another question here. If we don't use all the PPP funds at the end of the 8 weeks, can we give bonuses to our drivers to make up the difference and be okay under the forgiveness?
Well, that's a good question. I would say from a lawyer's conservative approach, it's designed, the purpose of the loan is designed to keep payroll coming for your existing employees. Certainly a bonus would be payroll costs, but if it's not something that's in the ordinary course of what you're doing, I think it could be looked at askance as a way of trying to make up that amount.
Steve, what if that's done during the 8-week period?
Well, again, if it's done in, look, I'm just giving you a conservative viewpoint here.
Certainly.
If it's done in the normal course of what you would do, I think that might be acceptable. But if it's not something that's in the normal course of what you do, it's going to, there's other portions of the act that talk about different things not exceeding what your normal payroll would be. I would just be a little concerned about something that was done out of the ordinary and could be viewed as a way of, trying to make up that 75%. I don't know if anybody else has a thought. That's, conservative approach. I would be cautious in that.
Yeah, Steve, I think the more conversations we have with carriers, the drivers are going to every length of getting the job done, and the normalcy of the job has changed considerably. So I can see where there might be some differences there. But
I'm sorry. Sorry, I didn't mean to interrupt. I apologize.
Go ahead.
I agree, and we're seeing that a lot for a number of reasons, where driver pay is being increased, and for a variety of reasons related to this crisis. And so again, if that's a part of a process that's unrelated to, I got to figure out how to spend this money, then I think that's a legitimate good faith reason for increasing the pay.
Very good. So what is the anticipated timing of receiving the funds once someone gets approved?
I asked that question to my banker yesterday, and he said, I don't know.
My answer is going to be about the same. We're saying a handful, 3 to 5 days from upload of all documents, and then 3 to 5 days once it gets to the SBA. So I think it's, probably up, a couple of weeks from if you got your application in on day one.
Well, it's going to be interesting to see how that turns out. I know it's on everybody's mind. All right, so here's a question that just came in. What direction can you provide for those with over 500 employees?
Yeah, so I'll just touch on that briefly because the answer is going to be yet to come. I believe that what we heard in the CARES Act was that the Treasury Department would issue guidance within 10 days, which I think would be tomorrow, from the time the CARES Act was signed for larger or mid-sized employees, which I think is 500 to 10,000. It appears that is going to be in the form of low-interest loans. And so, in any other scenario, a 2% loan with a long deferral period seemed like it would be amazing. But when everyone else is getting $5 million grants, all of a sudden that doesn't seem so attractive. So I think what we need to do is wait until the Treasury Department issues that guidance, hopefully in 24 hours, give or take, before we can really react.
Yeah, I agree with that. And, on those loans, at least what's in the act, and we've seen already how some guidance has come out that isn't completely consistent with what's in the act. But, there are some stipulations too, some significant ones about giving up the right to challenge organization efforts and things like that as part of that mid-sized loan package that's out there. But there are a lot of attractive features to it for as Randy mentioned, for folks that are in that next size up category. But I agree, we got to wait and see what the guidance says.
And then, John, if you don't mind, I just want to remind the viewers that you can meet the test in 2 ways. If you've got over 500 employees, but you meet the revenue test, you probably still qualify. If you're over the revenue test, but you're under the employee test, you probably still qualify. So just don't assume just because you're over 500 that you're automatically disqualified. You have to look in the SBA rules based on your industry code to see if you qualify.
So looking at revenue and then looking at number of employees. Good.
And I think for trucking companies, it's around $30 million. So it can be a relatively good sized trucking company can qualify for these loans.
Very good. That's going to be helpful. So to kind of wrap up a little bit here, Fred, most people watching today want the perspective of a fellow carrier during this time. How is the virus currently impacting your business, and how will the PPP program provide some insulation to the devastating effects of the economic shutdown?
Well, thankfully, to this point, no one's been infected, at least in our population. We do have a few people that we've advised them to stay at home. Certainly, the economic challenges are numerous. We've seen certain customers who have shut down because either they're non-essential business or they're related to the automotive industry and have shut down as a result of that. So there's been a little bit of fall off, not super significant. So we've seen an impact. However, we've heard cases of certain carriers being off 50% volumes, which would be really significant and very harmful to the company. As far as the PP program, certainly will help try to keep our employees active and employed. We've been hard at work chasing additional freight and are hopeful that we can use these funds to keep people busy and keep families fed during this period of time.
Fred, from a financial roadmaps perspective for survival during these unprecedented changes, what kind of best practices are you using? Is there any advice you give out to other carriers as far as some of the things you've looked at first and put up there as most important?
Sure. I would recommend to everyone that they track their receipts and their disbursements daily. Certainly to have a handle on what's coming in and what's coming out. Certainly to have an idea of what their liquidity is with their bank and what cash position they have available. I think a 13-week cash flow forecast is imperative at this point. I'd encourage you to share that with your banker on a weekly basis. We're doing so. That'll help us kind of stay ahead of the curve so that we can see 4 weeks from now, I might run into a little blip here. I'm going to need a little bit of additional liquidity at this point in time. Certainly want to monitor your customers' payments. That's very, very important. There has been some talks on other calls about the customers stretching out their payment terms. We've been able to mitigate that, but we have experienced some of that ourselves. Another recommendation would be to reach out to every single one of your key vendors during this time period. That's banks, insurance companies, asset lenders, whoever, and ask if you can get any extension in terms on your payments during this time period. The banks have been very, very receptive during this period, even offering up what I'll call principal holidays for a short period of time. So I'd urge you to pursue that avenue and have those open and honest discussions with your banks. Finally, we perform what we call a dry powder analysis. So take stock in all your assets that you own. Identify what the fair market value of those assets are. Any that do not have a lien or a loan associated with it, they could potentially be used at some future point, if need be, for some kind of sale leaseback agreement. Or if the fair market value is way in excess of the current loan value, you may be able to refinance that property and also inject some liquidity into the business in the short term.
Fred, that's excellent. Thank you very much for sharing that. Are you having a lot of conversation with other carriers? If you come up a challenge that you're not quite sure of, what does that conversation look like?
Myself?
Yeah.
Very limited. It's more secondhand knowledge at this point in time. We do have a large petroleum hauler just down the road from us, and they've seen a significant impact on their volumes, servicing both just consumers and also the airline industry.
Very good. All right, thank you. So should carriers be proactive in assisting their owner-operators in applying for their own loans? Brad, I put that out in front of you and maybe Steve.
David Rush from KSMTA provided a link. It's called an Owner's Operator's Guide to the CARES Act that's put out by another entity. It's short, 10 pages. It's very much to the point, easy to read. And I've encouraged our HR and safety department to hand that out to our owner operators if they're asking questions around that, at least as an initial guide to help them kind of navigate through this time period.
And that's David Roush.
That is correct.
David, very good.
Yeah, and I think the group he's talking about is ATBS, who has a great practice with owner operators. So, yeah, I would encourage people to look at that as well.
Yep, absolutely agree with that. You know, certainly we want to be compassionate in these times and provide assistance and guidance where we can. Again, I'm going to give the cautious view that says let's not, you know, we want to be careful. I think it's perfectly fine to give out that information, particularly from ABTS and others like that, and to kind of give guidance as to where they might look for assistance. We just want to be careful in not getting too far into the actual hands-on assistance of you know, helping them with, you know, loan applications or things like that, so that we don't want to cross that line of looking like we're controlling or influencing their business decisions, but absolutely providing guidance as to what's available, you know, I think is a good, you know, fine thing.
Couldn't agree more, Steve. We all have too much to do at the moment.
So this is kind of a closing question. Kind of encompasses our discussion today. What steps should companies be taking to ensure they take advantage of this program? It's a really, you know, broad question, but any sage advice?
I can start if you like. I mean, I would talk to your banker, talk to your accounting firm, talk to your lawyer immediately. Begin to navigate through the SBA website. There's plenty of information out there. It's very helpful, very easy to read. The form is very simple, but ask for help.
And I'll echo those sentiments from Fred. I think that's exactly right. And I think I've been encouraged a lot the last week, just the number of phone calls with clients that I've had. And I'm learning a lot from different people's experiences. And you know, one carrier, for instance, was highly acquisitional in the last year. And so banks are taking a different approach on what the last 12 months means. Is it a trailing 12 months or is it the last calendar year? And, you know, I guess the point I'm trying to make is understand how the different calculations and how your bank views it, how it impacts you. And some of those conversations are going to start with your legal counsel and your CPA firm. And then that allows you, when you go to your bank with your application, to be upfront with how you think that the calculation should work, and get some guidance as you're submitting the application.
Very good. Any closing comments, gentlemen? Okay, well, we're going to bring TCA's town hall meeting to a close. I want to thank Fred Price. Fred, you've been wonderful. Rainey, Hooper, very good job. Thank you. David Robinson and Steve from Scopelitis, and Michael Leach. Letsch, thank you very much for everything from Bank of America. So with that, we're going to close down, and I want to thank you again for participating, and for all the listeners and viewers. We're all here and available to help you in any way we can. God bless you and stay healthy.